Hi, welcome to Hill and Ponton's Q&A. I'm attorney Shannon Brewer, and today we have attorney Shelly Mark, and we'll be answering your questions best we can. We're apologizing for starting a little bit late. We had a couple of technical difficulties, which we are hopefully behind us. So we're ready to start with your questions.
Okay.
Okay. Eli Riddle, thank you for your question. Thank you for helping my fellow veterans. I had an informal conference for HLR for a rating disagreement, currently sitting at 110 days. How long does a decision typically take from this stage? So I would say you should have probably had a decision, or you should be getting one imminently. I would say if you haven't seen something within a week or two, I would start probably bugging the VA. We're seeing a couple of months, 2-3 months for HLR decisions typically. Is that what you're seeing, Shelly?
Yeah, I agree. And especially if you've already had the conference, usually after the conference, unless they issue like a duty to assist here, they normally get the decision out to us. Probably, yeah, I agree with you, like 60 days. Sometimes it doesn't take that long. So I would definitely start following up on that. Okay, Greg, if I opened a claim on August 1st, 2023, and am awarded 100%, is the 100% start the day awarded, or do I get 100% from August 1st? So if you opened a claim on August 1st and it was awarded on September 1st of 2023, then your effective date would be August 1st of 2023. So it would be the date that you initiated the claim, not the date that it is awarded. I think that clarifies. Shannon, do you think that's what's being asked here?
Yeah, I
I
think
think
the date
so.
of your claim is the effective date typically, or it should be. If it's not,
Right.
VA may have made a mistake. I'm not going to say they always get that right.
That's true.
Okay, we have a question from Michael LeMay. I have a CMP next week to take a pulmonary diagnostic test for bronchiolitis, VA presumptive. Is this just for rating purposes? They have to give you a CMP exam, or they're going to give you a CMP exam for rating. Yes, I don't know. It's not a presumptive for everyone. So assuming you meet all the qualifications for it to be a presumptive condition for you, then yes, this would probably just be for rating purposes. They look at the pulmonary function tests to decide how to rate it.
Okay, this is Chris B. 0995 filed within 1 year of the decision made. Will still keep original intent to file from that decision, correct? That is correct. As long as you have appealed the decision within 1 year of the decision, but as long as you file the appeal within 1 year of the decision, then your effective date will still be the intent to file that initiated the claim.
Yep. Once a Marine 95, do VSOs have quicker access to veteran C files? So I'm not sure quicker than who.
Yeah.
Basically, VSOs and attorneys who have gone through the VA's accreditation process are able to go in and look at your C file online. They have we're able to go in and see what's there. That's going to be a lot faster than waiting for a C file to be sent to you from the VA. So if that's what you mean, is it quicker for us to get it or for VSOs to get it than a veteran? Yes, we can usually download it within a few weeks of becoming the representative.
Yeah. Oh, okay. This is cystic. Half if you had cystic acne, head, neck, and back documented in MEPS, went to your duty station and they didn't have a dermatologist for a year, gave you the same diagnosis and prescribed Accutane. Can you still file a claim for acne because scarring got worse in the absence of a dermatologist? Also had 5 laser surgeries to improve it, but still didn't go away completely. Interesting. Well, I would say this, that you're going to have to do some development on that. And if you can get a link there, a medical nexus statement from a doctor, linking your current scarring from your acne to the initial condition and possibly the worsening of it because of the lack of treatment, um, then you possibly could get that service connected. I don't know, Shannon, you have any ideas on that? If anything different?
I if I'm understanding correctly, it was a pre-existing condition when you came into service, and so you would have to be able to prove that it got worse.
Mm.
Um, I don't know. That's going to be hard to prove. I mean, depending on when you were in service and what evidence you have. So if you have some evidence from your doctors prior to service showing it was not that big, it was you had it under control, everything was good, there was no scarring, and then you've got some records during service showing that there was scarring on the face, etc. Then you can possibly show a worsening. It's going to be hard to show that unless you have records. It's not impossible, but that's a hard one. Let's see. Jodoc, what are you seeing on your end given the huge influx of new rating employees at the VA? Are they mostly showing the same time rating approval percentages, quicker approvals to get them out the door, or much more delay given the inexperienced employees? I'm not seeing more delay. I wouldn't say I see much difference, to be honest, yet. It's we get a lot of bad decisions. We always have. You get some good ones too. I haven't really noticed any particular difference in the quality or the speed of the decisions lately. Shelly, have you seen anything?
I haven't really seen anything that, any kind of significant difference, honestly. It's still about the same. Yeah, I agree. Okay, Andre Evans. Once the administrative law judge has your notice of disagreement on a direct review, how long before the judge grant, denied, or remand? This is a tricky question. um, so this is basically saying that your claim was denied at the regional office and you filed an appeal up to the board asking for a direct review, meaning that you're not submitting any evidence. Gosh, I would say right now, honest estimate, um, 2 to 3 years. Shannon, would you agree with that? I mean, I think we're getting some back 2020,
Yeah,
maybe 2021. Maybe I think even 2021, maybe pushing it.
the most recent decisions I've been getting from the board have been that aren't legacy, that are the new AMA system, are 2020 appeals.
Yeah,
So I'm
that's
seeing about 3 years.
Yeah. We do see some more quickly than that if it's an advance on the docket. Keep that in mind. If the veteran's 75 or there's a homeless situation or something like that, you can then file an advance on the docket. But other than that, we're seeing some pretty lengthy waits
Yeah.
at the board.
There's if you have an expedite, that can go quicker. If you're over 75, those are going really quick. If
Mhm.
you're over 75, I would say you're looking at more like months,
Yeah.
than years. But if you're, and then also if there's a terminal medical condition or a financial, and when I say financial, I mean like a foreclosure or,
Right.
homelessness, those are moving quicker. The financial ones are not moving nearly as quickly though as the terminal condition and the age.
Yeah.
Tremaine Priolo, can you qualify for 100% VA rating for asthma if you require monthly injections of Tespire along with other medications? I don't know that medication. Like I'm not sure. Is that if it's a corticosteroid, um, then I just I'd have to look at the rating code, the diagnostic code for that and see what the requirements for the 100% are. Um, I can't tell you off the top of my head. I'm sorry, but I would recommend looking at the diagnostic code and seeing if there is, if it says for a corticosteroid you get 100%. It would probably need to be a systemic, like your take. It's not like something that you put on your skin, or that you. I don't know. Shelly, do you know?
I don't know. I'd have to look it up as well. Sorry. This is from, is it Jodoc? Is linking increased herpes outbreaks as secondary to depression or anxiety been a successful route in your experience? Um, I can honestly say that I haven't had that. I haven't filed that myself. I suppose if you can show that that's related to the mental health condition and that there's a positive link there, then you could prove the service connection.
Yeah,
Shannon, anything?
I think you'd need a medical opinion. Um, oh, hold on. I just got a notification that for the Tezspire, it does have to be a systemic high dose. So, so possibly yes for the 100%. I'd have to look at the medication, how much you're taking, and things like that. But so yes, possibly. Okay. And for this, back to the Jodoc question, I think you need a medical opinion. If your doctor says yes, your depression, anxiety is causing increased outbreaks, possibly you could do aggravation, but you'd have to show. I mean, you'd have to have a doctor's opinion showing that your condition is worse, measurably worse, due to the depression. Tianhua, what? Getting ready to file for an increase. Lots of medical evidence, which will be denied. When should I get an attorney involved? I would always say, I mean, you file it on your own. File for the increase, see what the VA does with it. They don't always mess it up. They may give it to you. They might get it right. If they ask you for something specific when they deny, you can try giving them that. If you don't know what to do, that's probably a good time to get an attorney involved. If they're still saying no to you and you've given them everything you have and you don't know what else you need to do, I would say that's probably a good point to get an attorney involved.
Okay, Charm Domes. Please talk more about missing organs specifically for hysterectomy. I received a partial and got 50%, plus I get K for missing organ, presently at 30%. Okay. I'm not really sure here. Again, I think I would probably have to go look at the rating schedule to be a little bit more specific about the actual rating. I can't. I received a partial and got 50%, plus I got K for missing organ, presently at 90%. Not exactly sure on that one. I would say that I could definitely look at the rating schedule, and I would need to look at, obviously your records and the rating schedule, and see what we could do to possibly get an increase from the 50%. So I'm sorry, that's not probably the best answer, but
Yeah, it depends on the organ and what kind of, you do have to look at the diagnostic code and see, there's some things they take it out and there's not really a rating for that. I know, like for a kidney, if they remove it, I think the minimum is a 30% rating for that if you have no residuals from having the kidney removed. So there's usually a percentage associated with it. I don't know what the percentage is for a hysterectomy, but usually there's a minimum percentage, and then above and beyond that, to get above and beyond the minimum, you would need to show residuals that aren't covered by that. So you'd have to show symptoms that aren't contemplated by the rating code. Frederick Brown, I've been waiting for retro back pay for 2.5 years, waiting to be seen by a judge. What is the average wait time? Is there anything else we can do? So I think we kind of already answered this question somewhat, but if you're at the board, it's going to 3 years is not unheard of and is probably standard. I think you're going to be waiting that long. So, you're in the home stretch, I can tell you that. But the only thing is if you have criteria for an expedite, and we kind of talked about that too. If you're over 75, they should be expediting that. If you have a terminal medical condition or failing health, you can ask for an expedite. And if you have a financial issue, you can ask for an expedite. Other than that, it really is just wait. Okay. Uterus in both ovaries is 50%. Thereafter, the 100%, 3 months after removal. So it's 100% for 3 months, and then it goes down to 50. So 50 is probably the correct rating there.
Yeah.
Sorry, we went back to a previous question.
Oh, there, the question's back. So I think that clarifies that. Thank you. Okay, Michael Stevens. If someone is 100% permanent in total, does the 5-year rule apply? And if I don't open another claim, can the VA reopen your file and try to decrease you? Okay, so if you're 100% permanent in total, the permanent in total should keep the VA from bringing you in to evaluate your claims to see if there have been improvement, which would lead to a reduction of your benefits or your ratings. Kind of the caveat that we always give to that is that you need to be careful once you have reached 100% permanent total not to initiate a lot of claims, because that can also trigger CMP exams, which could potentially lead to a reduction in your rating. But no, the VA should not be proactively bringing you in to evaluate your condition to see if there's been any improvement.
Yeah, I would say, VA always can reduce you until you hit 20 years when they have to show fraud. They can reduce you, but are they going to? It's less likely if you're permanent in total. They don't have any reason to create work for themselves. They're already behind. So they're not going to, go open random files and try to reduce you. LJZ, currently pending higher level review for pain. Pain is currently not service connected. The decision review officer found a duty to assist error for federal records review for pain and sent back to VSR for duty to assist. Was the DRO decision truly a decision? There was no information on what to do if you have questions about our decision included in the letter or further instructions. So it's not, it is a decision, but the decision is we messed up and they're sending it back for more development. So it's kind of a remand in a way. It's basically the higher level review said, okay, we didn't do something we were supposed to do. So we have decided that we are sending it back. There's nothing to appeal there because it's not a denial. So it's not technically a final decision. They're just shifting it. Since current status of HLR claim is duty to assist for federal records, can I still withdraw the claim? You can always withdraw a claim. I don't know why you'd want to, because then you're going to lose your effective date. So if you're no longer interested in pursuing it, yes, you can still withdraw it. Oh, this is still the same.
Oh, okay.
It's the same. VA primary doctor wants me to see the neurologist, migraines, and endoscopy probe test for GERD. Should I attend? Can these tests lead to possible unfavorable results in treatment records? I'm not sure what you're getting at here.
Shannon, I think maybe they're saying that the DTA was for development and that maybe they've now scheduled these exams.
If
No, I'm
those are
sorry, that's not right.
CMP,
It says my primary doctor.
yeah. I don't know if it's a CMP exam. I'm going to always tell you to go to those. I just feel like that's I think that's always a good idea not to give the VA an excuse to deny you. But I'm not sure. If your primary doctor wants you to see a neurologist, I would you always want to do what's best for your health. If they think you need to see a neurologist, you might need to see a neurologist. I would generally, we can't give you medical advice.
Yeah. Michelle Torado, how do I obtain my mental health records when they're confidential? Um, so I'm not sure if this is referring to mental health, private mental health records, after service, or this is service medical records or VA records. Um, but you should be able to obtain a copy of your mental health records. As long as you're requesting them, I don't see any reason why a doctor or a facility wouldn't release the records to you. um, I'm not sure what the situation would be that they would be telling you that they're confidential and that you can't have a copy of your own records. Um, I've never had that situation.
I haven't
Uh,
ever come across that. I mean, we've had situations where they didn't want to give them to us without,
yes.
the veteran needs to say that that's okay. But I haven't ever had a veteran who had a problem getting their own mental health records. They should, as
Should,
far as I
yeah,
know, they should be giving those to you.
yeah.
Okay, Wayne K. I have a CMP next Monday for hearing loss increase, now 30% and 10% tinnitus, but my hearing is shot, total 90%. Any advice for the CMP? Thank you. So for hearing loss exam, it basically the way they rate hearing loss is strictly on the numbers. So they're going to see, at what level you have impairment. They're going to average the different tone thresholds, and then they're going to look at your speech recognition, and they kind of have this complicated uh, graph where they put one against the other and figure it out. So it is purely numbers based. I would just say, I mean, they'll walk you through it, and it should be a situation where, they'll ask you, can you hear this? You just respond honestly. And that's the best advice I can give you on that is if you can't hear them, don't try to guess what they're
Mhm.
saying. Just say, I can't hear you. So it's based strictly on a numbers test. Shelly, any better advice than that?
No, I think that's all I have too. I mean, I totally agree with you on the not guessing though, because I think some people feel like, oh my gosh, I have to try, I have to guess, and you don't have to guess. You can say, I can't hear you. Sorry.
Yeah, if I don't know what you're saying, if you don't know what they're saying, then you don't know what they're saying.
Mhm. Kenneth Irvin. When an individual submits an initial claim, is it handled by one VA rater? If not, how does the process work? It's a good question. I'd like to know this sometimes. Um, I can't honestly tell you exactly how many people are handling the claim after you file it at the regional office or at the board for that matter. I can tell you that we have access to part of the VA system, and we can go on there and we can see that the claim goes back and forth, from multiple people that are working on it, depending on what they're doing at that time, if they're setting a CMP or if they're doing records development or something like that. I can say that it's not handled by one rater. It may end up going back to the one rater after some development is done, but I don't think that the claim is unfortunately not completely handled by one person.
MH. TDIU supplemental claim dated August 2021. The same claim has mental health secondary to IBS that could get me to 100% that was originally dated March 2022. Could I get approved for TDIU and 100%? Yes, absolutely. Okay, I had to reread that. Apologize. So yes, you can. Now, a trick that VA likes to pull is when they give you your rating, they will say you are 100%, and they will say TDIU is now moot. If they didn't give you the 100% all the way back to August 2021, if they only gave you the 100% as of March 2022, then TDIU is not moot. And you can appeal that and say, no, I want you to consider the TDIU prior to the 100%. So you would appeal that period of time. Sometimes they get it right. More often than not, I find that they don't get that right. When they grant the 100%, they want to just say, okay, we're done with this, but they are not. So
Mhm.
yes, you can absolutely get both, and you should appeal that if you don't.
Yeah. And just a note there, Shannon, that is one issue that we've been successful at the regional office filing the higher level review with a conference, just to point
Mhm.
out to them, hey, this is not moot. This goes back to August of 2021, not March
Yep.
of, or not just to the 100%. So that's an option for you if it is not proper, if you don't go all the way back.
Yeah, I agree.
Robin Lee submitted intent to file September 2022, then FDC in April 23. Will retro pay be intent to file date or FDC date? My understanding is that it would still be the intent to file date, which would be the September of 2022. The claim was submitted within 12 months after the intent to file. So I think that would be the correct effective date.
I agree. Okay, Robin Lee. DAV representative insisted I claim MST, military sexual trauma, even after I told her I never reported or told anyone, so had no evidence. Now held up claim. Can I tell VA no to requesting medical records? They have all because it's fully developed claim.
Mm.
So you can waive your right to have VA get medical records. If you do that, you give up the right to later say they didn't fully develop your. It limits your appeal rights later, because if you tell them no, they don't have to get everything, then they don't have to get everything, and you can't later come back and appeal and say they didn't get everything. So I generally am not in favor of waiving your rights to anything with the VA, but yes, you can. And that's yes. Shelly, do you have any input on that?
Yeah, I was just thinking, I agree with what you said. I think you could absolutely waive it. I don't know that you would want to. I don't know what negative would come from them requesting the medical records. And I don't know if maybe you're asking that just because you filed it as a fully developed claim and they're now needing to do development. But one of the things, I was just going to mention that with MST cases, even though you didn't report it or tell anyone, or maybe go and talk to a doctor about it, but there are other ways that we can look into the record and find certain markers and things to support the claim. So it doesn't necessarily mean that the claim cannot be proven. It does probably mean that it's going to take a little while longer, though. But just a
And it said now held up claim, so I'm assuming that the issue is that you don't want to delay. But we kind of always say yes that takes a little longer is better than a quick no.
agree with that. Okay, Julie Dupree. My husband has had a secondary tinnitus since October of 2021. It was appealed to HLR, which established a duty to assist error. It's not moving. Should we call someone for more information? So it sounds like it was filed in October of 2021, denied, then a HLR and a duty to assist error. Sometimes these duty to assist errors do take quite some time, especially if there's some development. Even still, it shouldn't take that long. I would say if you're looking at anything close to like 6 months or so, I would definitely be reaching out and trying to get some information. Ask them, is there anything you need from us? What are you waiting on? Can we help you with that? Um, I don't know exactly what they would be developing for, but yes, I would definitely follow up on it.
I agree. It's never going to hurt to call.
No.
Charles A. Why is it so hard to get migraines approved as presumptive under Gulf War illness when it states that headaches are a presumptive condition? That's a great question. I couldn't say specifically migraines. A lot of times what we see, or that I see as a problem with service connection, is there's a checkbox on the CMP exam where the doctor checks a box whether they feel like your headaches are prostrating or not. And I can't tell you how many times we have had to appeal that issue. it's literally just a checkbox, and if they mark no, then VA denies. And the thing is, there's no definition for what prostrating means, but what we know it means is when you have to go lie down in a dark, quiet room and you feel nauseous and you can't do anything because your head hurts so bad. To me, that is prostrating. VA has never defined what it means, but they sometimes think it's that, and sometimes they seem to think it's something more. So right now, the biggest obstacle I see is there's no definition for prostrating, and we have been fighting that for a while.
Virginia Sorensen. Hi, could you do a mini series on how claims regarding female anatomy issues, how menopause affects mental health ratings, migraines triggers versus PTSD triggers, female ED caused by mental health medications versus hormones, etc. I think that's something we can absolutely look into. We will pass that along and see if we can possibly do something in the future to address those issues.
Robin Lee, fully developed claim is still in evidence. Gather review at 205 days. Is this normal? That seems long. That seems long to me
It seems
too.
long.
Yeah, if you're like Shelly said earlier, I think if you're getting over 6 months, at the regional office level, I'm going to start pushing on that.
hmm
Yeah, I agree. That seems long.
Peggy Cooper. Why does expedited case take so long? Been waiting forever, and now my husband has been put on hospice. I'm so sorry to hear about your husband. If you're, I'm not, I don't think I really know all the facts here. I'm not sure if this is a claim for you or if it's a claim for your husband. I will tell you that if it's a claim for your husband and your husband has been put on hospice, then I would absolutely get that paperwork or some documentation to the VA, and I would do another expedite asking them based on his being on hospice for sure. That shouldn't that should absolutely be approved if he's on hospice.
Yeah, I agree. That's an
And yeah, and just in general, I'm sorry, Shannon, I didn't mean to cut you off. If you file a request for expedite and you don't get a response, and it's a legitimate request for expedite, refile it. Like it's not going to hurt anything. They just come back and tell you no, but things get lost or mislabeled. I don't know how often we submit something and it's unsolicited evidence. So no one's looking at it. So it's not going to hurt anything to refile it.
No, and that's going to be, I mean, that is an expedite that gets granted. So if he's on
Absolutely.
hospice for any reason, I would submit that paperwork and let them know that, and file,
Yeah.
like Shelly said, file the expedite again. Robbie Rutherford, I have neuropathy, sleep apnea, IBS, in addition to small lymphocytic lymphoma. Can I claim any of these as secondary to the SLLL? Oh, the small lymphocytic lymphoma. Um, Basically, if your doctor says they're secondary to, then yes, absolutely. What you need in that case is a nexus. You just,
Mhm.
if the small lymphocytic lymphoma is service connected, which I'm not sure if it is or not, um, then all you need is a medical opinion from a doctor saying that the neuropathy is secondary to that, the sleep apnea, the IBS. Those specific conditions, I don't know. I haven't had those specific conditions come up in conjunction with lymphoma. That doesn't mean they're not. And sometimes it can be the medication that you're, like IBS, particularly the
Yeah.
medication you're taking for your condition can cause things like that. So basically, yeah, if your doctor says yes, then yes.
Let's see. I'm sorry. Does that say gravy?
Gravy, I
I
think.
Is it gravy? I apologize. It's hard for us to read the names on here. Can I get back pay to 2011 if the VA submitted a second claim on 2019 and they only back paid to the second claim. Um, so that really depends. That's a very fact specific question. So we would really need to look at the file to see if we could get that back to the original claim in 2011. There are limited situations where we can do that. Normally, if you file a claim and you get a rating decision and you don't appeal it within 12 months, it becomes a final decision. And then if you file a supplemental claim, let's say then in 2019, that's going to be your new effective date. There are some instances where we can argue back to an earlier effective date, but that's something where we wouldn't be able to tell you until we actually really sit down and do a really thorough review.
Yeah, the general rule is it's going to be the date of your most recent claim. So you have to look for an exception to go back to 2011. Okay, the experience. What does 100% permanent and total for PTSD, depression, and schizoaffective mean? Um, so if it's permanent and total, I think we've already discussed this. It means that they are not going to take it upon themselves to bring you in and reevaluate your condition. So it generally means that's your rating unless they have a reason to reduce you. And a reason can be things like you filing something new. They go into your file, they look at your medical records and say, oh, your PTSD is not that disabling anymore. The If you're asking about the rating code specifically, the difference between 70% and 100%, I mean, it's based on your symptoms, and um, 100% means total occupational and social impairment. 70% is occupational and social impairment that is not total, but it impairs you, as far as in most areas, your ability to work, your ability to get along with other people, family members, things like that. So it's kind of a subtle, the total versus total social and occupational versus just not total social and occupational impairment. It's based on the symptoms, things like that.
Yeah, I agree. Sergeant, like mad dog, got it. All right, 1 of 5, my current rating evaluation of lumbar cervical strain with degenerative arthritis of the spine, intervertebral disc syndrome, spinal stenosis, and lumbar disc disease. 2 of 5, previously rated as bulging disc, lumbar spine 20%. I read the following. If you are already service connected for degenerative arthritis of the spine and develop neck strain, you may not necessarily need a nexus letter. Since you are already service connected for a condition related to the spine, the development of the neck strain and arthritis could potentially be considered secondary. I have horrible neck pain and limited motion with supporting x-ray and MRIs. Should I still get a private nexus? And then this is just my opinion. You could certainly submit it without a nexus and have a CMP done and get the examiner's opinion and then make a decision on your own, but I would probably go ahead and get an opinion that it's a secondary condition to your service connected lumbar and submit the claim that way. But you always have the option of just submitting it and then, having the exam and getting that opinion and then going from there to determine whether or not you want to seek out another nexus opinion. Yeah.
Is that still your question?
Yeah, it says, does Hill Ponton recommend doctors that will be willing to write a nexus? Also have radiculopathy, which is present, just like my legs, miserable, always in pain. Very sorry to hear that. That sounds like a very uncomfortable situation. We do have experts that we work with directly through Hill and Ponton. So if our clients come to us and we feel that they need a nexus opinion, depending on what type of opinion it is, we can work with our experts, determine which one is the best for their condition, and then have an expert opinion completed for them. Yes, but that's specific to our clients.
I can tell you, like, for this condition that you're looking at, you're going to want an orthopedic doctor to do this, or for radiculopathy. Well, the orthopedic could do the radiculopathy too. That's nerve pain, but I would go with your treating orthopedic. You could even get a chiropractor to talk about it if that's who you treat with. You can, whoever's treating you for it should be able to give you an opinion on that, and you could start with that. Michael Pollitt. So I have pretty bad kidney stones and was denied an increase for them, currently at 0%. Do you know if diet therapy and drug therapy are still considered? I would have to, again, I'd have to look at the diagnostic code for kidney stones. It has to be pretty bad, I think, to get a percentage rating. And I don't know, off the top of my head, I don't know what the diagnostic code says about diet therapy and drug therapy for kidney stones. Do you know, Shelly?
I don't. I would have to look it up as well. I do agree with you that I know that we had a case recently, and I know that it has to be quite severe to get a compensable rating, but I'm sorry, I don't know exactly what it is. Wit, how long are CMP exams considered to be current for rating purposes? Oh, that's a good question. I don't think there's any definite answer there. I think that sometimes we have clients who have a CMP exam and we file an appeal, and 3 months later we have another CMP exam. So that happens. And then sometimes we have a claim that's been at the board for years and there's a remand made, or a grant of benefits, and the regional office grants it without a CMP exam, and there hasn't been one in 3 years. So I think it definitely depends on who's working the case for sure.
Absolutely, it does. And we see, I think one of the most frustrating things I've ever seen, and it happens frequently, you file a board appeal, you wait 3 years, and you get an opinion saying, well, we don't have a current exam, so we're going to
Exam.
need to send that back. And that's, which I disagree with vehemently, but they do it.
Hmm. Yeah, that's cringeworthy. You're just like, oh,
It really is. That's why they call it the hamster wheel.
yes.
Okay, let's see. Sergeant Mad Dog. Carol always says to file it. If I submitted a notice to file and will only submit one claim, is there still an advantage to filing over notice to file? No, I mean, if you're asking whether filing an intent to file or actually filing your claim, it there's no advantage to either. I mean, you're going to get the same effective date. The only thing is, if you don't know what you want to file for at this point, just file the intent to file, and then but just make sure you file all your claims together when you file them. Because if you file one claim 6 months after your intent to file, and then you file another claim 3 months later, it's only the first one that's going to get that intent to file date. So just make sure, if you're going to submit other things, file them all together. But if you're only submitting one claim, there's no reason not to just go ahead and file the claim.
That's a good piece of advice, to make sure you file them at once so that the intent to file applies to all of them, because we see all the time where there's the intent to file and then multiple claims filed after, and it only applies to the first. Nicholas, how does the VA rate two different types of cancer, melanoma and thyroid? Well, if the cancer is active, then the VA is going to rate it at 100%. And then after that, it's going to be based on the residuals, which will be specific to the type of cancer that's service connected. And that probably oversimplifies it quite a bit, but that's basically how they're going to look at it.
Okay, Dave Spangler. I submitted a claim in March of this year for PTSD, anxiety, and sleep disturbances. Have since been diagnosed with sleep apnea. My question is, will they automatically place to sleep for my claim? So if you're asking what, okay, I think I understand here. So if you're asking whether they're going to turn that sleep disturbance claim into a claim for sleep apnea, they are not. If you filed it with the PTSD and anxiety, they're going to assume it's insomnia or it's nightmares or it's something related to your PTSD. I would go ahead, if you're wanting to file a claim for sleep apnea, just go ahead and file the claim for sleep apnea. You might be able to like harness it in there and try to wedge it together, but it's I would go ahead and file it. Otherwise they're just not going to process it. They're not going to treat the sleep disturbance claim as a sleep apnea claim. Whether they should or not is a different story, but what they're actually going to do is they're just going to decide mental health.
Dave Spangler also had a favorable CMP exam in April, but still waiting patiently on my claim. Why is this taking so long? That's a good question.
If you
He
had a
had a
favorable CMP exam, they should have already decided that.
yeah.
I would poke them about it,
Mhm.
give somebody a call, send in a letter, demand that they make a decision on your case. They should have done it a long time ago.
Yeah.
Rec 101. I was recently last month awarded bumped up from 70 to 100% due to, according to the CMP examiner, the worsening of 31 of my mental health disorders. And we recently applied for aid and attendance. Will there be another CMP? And also, what type of evidence will be required to be approved for ANA? So aid and attendance, yes, they probably will give you a CMP exam. They'll give you one anytime. I mean, anything can trigger a CMP exam. Yes, they probably will. Aid and attendance, you need to be able to prove that due to your service-connected mental health disorder, that you need someone to be there with you and help you with your daily living tasks. Whether that's you need somebody to help you because you don't remember to turn off the stove, so somebody else has to cook for you, whether that's you need somebody to be there because you forget things, you don't pay your bills, you don't take your medication, or if that's you might leave the house and get lost. If that's it depends on your symptoms, but what they're going to be looking for is you need someone to help you regularly with daily activities. So that's the type of evidence. You would probably want to get a statement from the person who's taking care of you, the person that's there with you, who provides that aid, and a statement from you talking about what kind of help you need, a statement from your doctor saying that you need that kind of help. That's the sort of evidence that you want to put together and give them.
Alex Garcia, what about legacy VA board appeal timelines? If you have a legacy appeal pending, I would be reaching out to somebody and asking them to make a decision on it. Those, they should be, I won't say expediting, but they should be the priority at the board right now to where they're making decisions first on the legacy cases. I think some of the advance on the docket cases with the newer AMA cases may be taking a little bit of precedent over some of the legacy cases, but it they should be making decisions on legacy cases like now.
Yeah, they say they are prioritizing those, so absolutely, they should be moving quicker. I can tell you with legacy, one thing: if you ask for a hearing,
Mm,
get out of it. Go ahead and send a letter. If you've asked for a hearing in a legacy case and they haven't scheduled the hearing yet, unless you want the hearing. Now, I mean, if you want to go to a hearing, by all means, you can wait for it. But if you can go ahead and let the VA know, I don't want the hearing anymore, just make a decision, that sometimes can speed things up a little bit
yeah.
because they have a line waiting for hearings. Okay, Edward Tuma. I have diabetes and hypertension that are service connected. Both have caused chronic kidney disease. Can I claim this for compensation? Absolutely. And they will probably grant that almost automatically. Hypertension and chronic kidney disease go hand in hand. I have not even needed a nexus for a bunch of those. The CMP examiners are getting that one right. If they don't get it right, get a private doctor, and you can even get your own treating doctor to just write a letter and say he has chronic kidney disease caused by hypertension. So yes, absolutely file that ASAP.
All right. Sergeant Mad Dog, you ladies are rock stars. Well, thank you. What you do for this community is so valued and appreciated. Well, we appreciate that very much. And I know I can say that we love what we do. So we're just happy to be able to be here and assisting all of you. So,
And on that note, with Veterans Day coming up, please know thank you for your service. We
yes,
sometimes forget to say that because we
we
do
do.
this all day, but we always mean it.
Yes. Happy Veterans Day.
West Bows. If I am denied for a Q, clear and unmistakable error, can anything else be done? My understanding is no recourse after denial. So it you can appeal a Q denial. So if you filed a Q or a motion for revision is what it's technically called at the regional office and they denied that there was clear and unmistakable error, you can appeal that decision to the board. So it's appealable. So you do have recourse and you can appeal that. You can appeal it to the court. You can, continue to appeal that decision.
Okay, Robert Lohman. Are HLR claim accuracy reviews still being done and are they actually being processed faster? Thank you. Um oh, I think this is the yeah. So, I have filed these a couple times. This is the car. Um to be honest with you, I have found that filing a higher level review with a conference is processed sometimes just as quickly as these. So I haven't really used these that much in everyday practice. I have a couple times and I've not had any better result with them than I've had with just filing a regular higher level review. Um, Shannon, I don't know if you have any different experience with these or.
I've done a few of them, like you said, a handful, because typically the HLR appeals are being handled really quickly. I'm it's not going to buy you a whole lot of time. It might get you a few weeks though, so it's they are still doing them. I don't know that they're that much faster that it's critical. You do have to file them within 30 days of a decision. So, it's you can't file one unless you're within 30 days of the decision, but um you you're it's as my husband six of one, half a dozen of the other. They're not that much faster, but they are maybe sometimes a week or two. It's a slim margin.
Yeah.
Just Fred. Primary doctor wants the specialist to do Nexus. Specialist says he won't do it. Suggestions. They there's one thing, a lot of doctors don't want to do a nexus opinion, and sometimes it's because they misunderstand what the process is and they misunderstand the standard for VA. So the standard for VA is as likely as not. It's not medical certainty. They don't have to be 100% sure that this caused that. They have to be as like it's 50-50. So if it's as likely as not that one condition caused the other, or something that happened in service caused the condition, they may not understand that. So it might be, if you tell your specialist that, they might change their mind, they might not. You can't make them do it. The other thing that might change their mind is the understanding that it's just a letter. They don't have to go to court. They are not going to have to testify. No one is ever going to ask them questions about this. They just have to send the letter, and that's all there is to it. You're not asking them for anything past that. That might change their minds. If it doesn't change their minds, you may have to get a private doctor to do it. If your primary, maybe your primary doctor will do it if he understands that the specialist won't. So go back to him and ask him. But you can also always get a private opinion from another doctor.
Jim Tablet. What is needed for filing and AOD? Oh, so you can just send a letter. Send a letter and be clear about why you feel you qualify for the advance on the docket. So, if you're over 75 years old, make sure you put on the letter that you're filing it based on advanced age and your date of birth, which they should have. And then obviously, if you're filing it based on financial need, most of these that we submit are when someone's in like a foreclosure situation, or they're being um, or there's a housing situation or something like that. You can submit some statements, like if you're behind on your bills or something like that. If it's a financial need, you're going to want to provide some evidence. And then obviously, if it's a terminal illness or something, then same thing, a letter. If you have records or some documents showing that, then I would submit that as well. But you could submit that. There's no special form or anything like that. Just write a letter.
I think we have time for one more question, two more questions. Can we do two, Shelly?
Sure.
Okay, two more questions. Okay, HT. Any advice for a veteran that has been waiting for a decision on a supplemental claim since a decision was back from the CMP exam since October 5th? So that's about a month. That's not unreasonable in VA world. That's probably I see that pretty often. You can write, you can call into the status line, ask them, what's going on with your case. You can send a letter asking for a decision, letting them know, putting out the facts. I filed the claim this date. I had a CMP exam this date. I still don't have a decision. I'm asking for a decision. Do what you can do to bring their attention to it. But that's not uncommon, a month wait after a CMP exam. So they have to have time to get the report back. They're going to review the report. They usually have what they call a suspension date. So they set a time limit when they expect the CMP exam to be back. They may not look at the case until that. So hopefully you'll have something pretty soon, I would think.
Okay, Mr. Handy. What is the success rate
Handy
of
dandy.
handy of OSA secondary to tinnitus? I don't want to try to say um, a success rate here. I don't. I think that this is going to depend on if you're going to get a nexus linking the two together. I think that obviously it's going to be a higher rate of success if you do it that way. But as far as a rate, I'm not really sure. I'm sorry. I don't.
Yeah, I
Mm,
generally find VA doesn't like sleep apnea claims unless it's related to your weight. They or if you had it during service, those are easier to grant. They do not like these cases. We can give the same exact evidence in two different cases. The same. You can look at cases that look identical. One's going to get granted, one's not. It seems to be pretty 50-50. I have not had I have not successfully done a case of sleep apnea to tinnitus that I can think of. They're hard cases, so I wouldn't say the success rate is probably high, but it always depends on getting a medical opinion. So if you've got a good medical opinion, that's going to improve your chances a lot, I think.
yeah, I think that would definitely. I mean, I think you would definitely have to have a good medical opinion for that.
Okay, so I think that's it for us. Thank you for joining us today. And again, thank you for your service. Happy Veterans Day.
Thank you. Happy Veterans Day.